Okay, here we are.
So should we wait just a few moments or?
We're on live. You can go.
So I start. Should I wait just a few moments so that the people who wants to follow there join us, or should I go right now?
They are already there.
Okay, okay. Perfect. So, yeah, I'd like to thank everyone who is here with us tonight, first of all, and in particular our guests. So I thank them for being here today. For those who haven't seen the first webinar of this series, we are Società Civile per la Palestina, which is a network of 24 Italian organizations committed to the promotion of the rights of the Palestinian people and the respect of the international law. As for me, I am representing in particular Giovani Palestinesi d'Italia, which is an organization of young Palestinians who are both born here or who came in Italy later on. And our aim is mostly to spread the Palestinian cause, the culture, and its history. So about today's topic, we do believe that the legal issue is one of the most important in order to understand the current situation. And indeed, the legal actions, and in particular the ones that are done in Israel and the occupied territories. And for this reason, we are very pleased to have Emily with us so that she can talk about this issue. We do believe that these legal actions are the first step in the defense of the human rights and are one of the most effective instruments to defend them in the immediate future. However, the problem is that Israel does not respect any of these rights, which should respect because it signed different treaties and it ratified different treaties, different international treaties that should defend the human rights. And this leads to the crimes going unpunished by those who committed it. Mostly because the lack of the political intention to prosecute them guarantees the immunity of those who commit the crimes. And this is true both in Israel and on the international community, because whenever there are violations made by someone in Israel against the Palestinian that should be prosecuted because they go against the Geneva Conventions, the Security Council resolutions are constantly blocked by the US veto. So this allows Israel to feel legitimized not to respect the human rights, both within its own jurisdiction and in the occupied territories. So for example, we can just name a few of these, like the lack of access to vaccines, the forced displacement of Palestinians, which we see every day on a daily basis mostly, and go on. One of the most important facts is that the Palestinians face increasing difficulties in accessing the justice system, both because of the racism, of the institutionalized racism of the Israeli legal system and the justice system, and because of the systemic discrimination that they face. So, having said this, however, it's important to highlight the International Criminal Court decision on its jurisdiction over the occupied territories, because these decisions gives us a glimmer of hope, and it offers the victims of serious crimes a real hope for justice after more than a half of century of impunity. And we do believe that the political aspect of the legal action, so as I said, the lack of political intention to prosecute those who commit crimes, both by the Israeli legal system and by the international community, is a major aspect of this topic. And as the title of the webinars says, the Palestinian rights are currently hostages of the diplomacy. So I thank again our guests today, because I do believe that understanding better these aspects and the potentialities of the legal action is a major aspect to understand the current situation of the Palestinian cause. And so I thank you all for the presence here today, and I'd like to invite you to follow us on Facebook so that you can keep updated about the following events. And I suggest you also to look at the previous event. And now I give the floor to our moderator, Pietro Caresana, who is a jurist specialized in international human rights and humanitarian law. So thank you all.
Thank you very much, Bassem, for the introduction, and thank you all for being here this evening. And I'm very thankful as well for our very, very distinguished guests for this evening, whom I will briefly introduce. Chantal Meloni. Chantal Meloni is an Italian criminal lawyer and professor at University di Milano, Statale, Italy, where she teaches international criminal law. In 2006, she completed a PhD with a thesis on command responsibility in international criminal law. She then worked at the International Criminal Court in The Hague as a legal assistant in chambers. From 2011 and 2014, she was an Alexander von Humboldt Fellow at the Humboldt Universität zu Berlin. Sorry, I don't speak German. Since 2010, she collaborates with the Palestinian Center for Human Rights and spent several months in the Gaza Strip, Palestine. Chantal joined European Center for Constitutional Rights in September 2015 as a legal advisor for the International Crimes and Accountability Program, and she's the author of a very relevant book, Is There a Court of Gaza for Gaza, which was published in 2012. Our second guest is Emily Schaeffer Omer-Man. She's an international human rights lawyer and litigator based in Tel Aviv. For more than a decade, she's been at the front lines of the legal battle against Israeli state and military policies carried out in the West Bank, East Jerusalem, and the Gaza Strip. Prior to co-founding a new law practice in 2018, she spent 10 years as senior counsel and 2 years as acting director of the Michael Svard Law Office, litigating on behalf of Palestinian petitioners before the Israeli Supreme Court and serving as legal counsel to human rights organizations, including Yesh Din, Breaking the Silence, Al-Haq, and Human Rights Watch. Additionally, she represents Palestinian communities in corporate accountability cases in foreign jurisdictions, including serving on the transnational legal team in the well-known Canadian lawsuit, Belain versus Green Park International. And Emily regularly lectures and comments on the application of international humanitarian law and international human rights law in the Israeli and Palestinian context. So I'm very pleased to have you here this evening, and clearly that the topic couldn't be more timely given the recent decision of the International Criminal Court, which we'll go through and try to understand a bit more. And what I think it's really important is to understand as well that the limits of the mandate of the International Criminal Court, which is a criminal court as such, and unfortunately it's only limited to war crimes, crimes against humanity, genocide, and aggression. And these crimes the court has jurisdiction only over individuals. So it does differ from the International Court of Justice, which is a completely different mechanism that adjudicates cases of international law disputes between states. And sometimes there is some confusion there, but I'm sure our guests will walk through the peculiarities of the current initiatives in terms of individual criminal responsibility. And then I will immediately move to the questions because I'm quite excited to have Chantal and Emily here. So I would start with Chantal. If you can briefly explain to us what this latest decision of the pre-trial chamber of the International Criminal Court means in practice, and what are the expected ramifications and scenarios. If you can give us a brief answer. I know there is no brief answer to that, but try to help us understanding a bit more. And of course, most of our audience is not lawyers, and let's try to make it easy to access for all of us. Thank you, Chantal.
Thank you, Grazia, and thank you for this really very, very nice invitation, and to all of you who are behind the organization of this event. I know there is interpretation into English and Arabic, so I will try not to speak too quickly. Let me know in case. Buonasera a tutti also, because I think most of audience is Italian, so è anche un po' strano parlarvi in inglese, però almeno abbiamo una platea più ampia. So I will try to briefly put the pre-trial chamber decision into context of a much, much longer engagement of Palestine with international legal institutions in general, but more specifically with the International Criminal Court. So what we need to remember is that already in 2009, after so-called Operation Cast Lead, Palestine tried to trigger the jurisdiction of the International Criminal Court in the sense that Palestine, back then, it was, as I said, after that very devastating military operation against the Gaza Strip, filed a document by which it was accepting the jurisdiction of the International Criminal Court. As maybe some of you know, the International Criminal Court is, as Grazia correctly said, a criminal court, which is established by an international treaty. It means that the court can only adjudicate over crimes, alleged crimes, that have been committed either on the territory of state parties, so those states who ratified the international treaty that established the International Criminal Court, which is called the Rome Statute, or those crimes who have been committed by nationals of state parties of the Rome Statute. There is an exception to this, and this exception is when the UN Security Council itself refers a situation to the court. In that case, as it happened, for instance, in Libya or in the Darfur situation, the court can have jurisdiction even if the state, the territorial state, is not a state party or the alleged suspects are not citizens. So what happened in 2009? As I said, Palestine, through a formal acceptance, wanted the International Criminal Court to start an investigation into what it was denounced to be war crimes, grave war crimes, and also crimes against humanity committed against, in particular, in that case, the civilian population of Gaza, of the Gaza Strip. And the prosecutor at that time took 3 years in order to come to the conclusion that because the status of Palestine under international law was uncertain, it could not decide whether Palestine was a state or not, and therefore was not in a position to open an investigation into the situation. That was 2012. What happened after that? Some of you will remember the very important United Nations General Assembly resolution of 29th November 2012, where Palestine was, so to say, upgraded to be a non-member state of the UN. After that decision, resolution of the UN General Assembly, which of course did not create a state of Palestine because there is not such a power under the General Assembly, but there was a recognition of Palestine as a state, the prosecutor of the ICC, of the International Criminal Court, announced that in theory, Palestine was now in a position to ratify the Rome Statute. And this is what happened in 2015. So in 2015, Palestine, the state of Palestine, formally ratified the Rome Statute and again asked through a referral that was then submitted 3 years later to open the investigations into the alleged crimes, in particular war crimes and crimes against humanity committed on its territory. So the prosecutor started these current proceedings back in 2015. And the decision of last December, it's very important because it concludes the preliminary analysis, which is called preliminary examination. It's a first, let's say, a pre-investigation phase before the International Criminal Court. It took very long. Yes, it took 6 years for the court to come to the conclusion that indeed the court has jurisdiction over the state of Palestine, which, and this is very important to understand, is not that the International Criminal Court recognized the state of Palestine in general, meaning under general international law. It did not create a new entity. We can debate, I know you already spoke about this in the last webinar organized by Grazia, and so we will not go into that today. The most important finding of the pretrial chamber of last December is that for the sake of the jurisdiction of the court, Palestine can be regarded as a state, and its territory is the territory that has been recognized as the Palestinian occupied territory, meaning the 1967. And here I stop. I know we will go back to this, but of course, this is just the starting point to put it back into the context. Grazie.
Sorry. Yeah, if we can briefly look into what can happen next. So what is the major breakthrough that this decision of the 5th of February 2021 has created? And perhaps Emily as well will have some comments on that. But Chantal, what is happening now?
What is happening now is that the prosecutor can open its investigations, and this is what we expect to happen very, very soon, because the prosecutor already back in December 2019 had concluded its analysis of the situation and had already clearly found that there are reasonable grounds to believe that crimes under the jurisdiction of the court, and in particular war crimes, crimes against humanity have been committed on the Palestinian territory, but by both sides of what she calls the conflict, meaning both by Israeli individuals, but also by Palestinians, in particular in Gaza, Hamas and other armed group members, and possibly also in the West Bank by the Palestinian Authority. In particular, she's talking about torture of Palestinian detainees. But for sure, the allegations against the Israeli soldiers in particular are very, very grave and serious, and they involve the commission of war crimes like indiscriminate killings of civilians, destruction of civilian property, and everything that goes around the settlements, and so the pillage, and the settlements can amount to a war crime under the Rome Statute. So this is what should happen next, that the prosecutor will, I believe she will soon open this investigation, which then will become, with the time, after the investigation is properly conducted, potential cases. And potentially we will see warrants of arrests, we will see trials, potentially, before the International Criminal Court.
Thank you very much. And I think everybody is very keen on understanding how these investigations can take place in terms of gathering of evidence. Would you have some thoughts on that? Perhaps Emily, given that she is operating in the territorial jurisdiction. So yeah, would you have some ideas on how the possible scenarios could be on that front?
Sure. I will leave Chantal to speak about the technicalities of the countries that are parties to the statute and thus have arrest power, and how that could work in terms of both investigation and future indictment. But we certainly can anticipate some procedural hurdles, even though according to the purposes of the Rome Statute and ICC jurisdiction, Palestine is considered a state. It still is an occupied state, and thus Israel controls all of its borders. And so even if Palestine were to welcome an investigation onto its territory, it could be prevented by the Israeli authorities. That said, there are plenty of ways for investigations to take place via investigators that already exist on the ground. And I don't know, maybe Chantal can comment on this more. I don't know how much the Office of the Prosecutor is authorized to sort of delegate some of those investigative powers, but I can understand why that might be necessary in this kind of case. And maybe Chantal, you want to comment on that?
Yeah, I think, of course, as you said, it will be very difficult to put it as an euphemism for the ICC investigators to access the Palestinian territory, given that, of course, it is under occupation, and ultimately it is Israel that decides who gets to go into the Palestinian territory, meaning both the West Bank and Gaza. So for the ICC investigators, it will be very difficult to physically travel there, although not impossible. And the last news are that the Rafah border, so from Egypt into the Gaza Strip, is now open. I don't know for how long it will be open. That's also a possibility to access the Gaza Strip. But otherwise, I must say that the ICC prosecutor office is used to these kind of situations. It happened already in many other cases where they didn't get any access to the territory. And what they did normally was to establish a sort of investigative mission that was able to travel next. So in this case, I could imagine it could be Jordan, which is a state party. And instead of going directly to Palestine to, for instance, take witness testimonies, they could have the witness testimonies come to Jordan. But this is just a speculation now.
No, I'm glad to hear that, I'm sure there are a lot of questions and like a lot of skepticism about the feasibility. We don't, underplay the difficulties, yet the court has been doing this for a while. So I believe they have they've developed the mechanisms. But what is the impact of this decision, Emily, in Israel? And what is the impact on your work as a litigator of Palestinians' rights in Israel? And what is that Palestinian clients of yours expect from you when you litigate their case in Israel?
Thanks. Sure. And I also want to, I just jumped in earlier because, this is such a fascinating topic, but I want to say good evening to everyone. And thank you again for the invitation. It's a real pleasure to be here with Grazia and Chantal. I think we've known each other. I've known each of you for more than 10 years now. And unfortunately, we just haven't been able to see each other in a while. So this is fun. I'll say, I kind of am living in two worlds because I am connected to all of my colleagues who, of course, are enthused and engaged and have been following everything that the ICC is doing, for the past 6 years very, very closely. And then I also am existing within Israeli society, and it's either something that is not talked about or that is completely delegitimized and viewed as one more external attempt to demonize Israel. That's a theme in the thinking. The headlines are, and this has been, the news cycle continues. It's one of the top 4 stories. I've been paying attention ever since, alongside Benjamin Netanyahu, the prime minister's corruption trial. So it's right up there. But it's been, been condemned. It's been raised as an issue that now requires the US to intervene. There's a big question mark next to whether the Biden administration will be as solid of a protector of Israel when it comes to the ICC and otherwise. But I will also say that there are even some voices, of course, from the right, or at least the center, that still believe in negotiations, and all the way to the far left that are wondering whether this move, that's not new, of course, by Palestinian leadership is going to cost them other potential avenues of reaching a just resolution to the conflict. So there's kind of a wide range of views, but the mainstream is total dismissal of the decision as illegitimate. So in short, I don't think that it's going to make a huge difference in the Israeli legal system as it operates. I think it's important to note that there's no official or robust war crimes legislation in Israel. There are certainly elements of many of the war crimes and crimes against humanity, and of course genocide, that are criminalized in the Israeli Penal Code, but not given the gravity that they need to be given as international crimes, as crimes committed in an armed conflict context. And one of the biggest, I would say, weaknesses of the Israeli legal system when it comes to Palestinian rights is the fact that Israel has never accepted the application of the prohibition from the Fourth Geneva Convention, which forms part of international humanitarian law, the laws that govern what can and cannot be done in an occupation, has never respected the prohibition on settlements, more accurately on transferring the population from the occupied territory from the occupying powers territory, in this case Israel, into the occupied territory. And so the system doesn't offer redress for Palestinian victims of such crucial violations that have infinite impacts on Palestinian human rights, such as settlements. And also the same can be said for punitive home demolitions and administrative home demolitions, where punitive are those where Palestinian homes of families of alleged, suspected, or in some cases convicted attackers, Palestinian attackers, who have committed attacks against Israelis, where the home of the family is demolished afterwards as punishment, and administrative demolitions, which are far more common and really ubiquitous, which have to do with the lack of building permits in a system that is built to not grant building permits for Palestinians in the West Bank and East Jerusalem. So, you have a legal system that already limits the rights and the legal avenues. So in this case, I don't see the decision changing those very fundamental flaws. On the other hand, I want to say something positive, which is that I do think that there's an opportunity here for discourse to change within Israeli society. And we already see it, even if these things can be polarizing. We already see the word apartheid, for instance, being used by not only Palestinian human rights organizations like Al-Haq, that came out earlier last year with a report, documenting and making the legal case for why Israel is operating an apartheid regime. But we also now have Israeli human rights organizations like Yesh Din and B'Tselem coming out with similar reports. And despite the lack of the imbalance in power, the fact that Israeli organizations now say the same things that Palestinian organizations are saying makes a difference in Israeli society. So it's not it's no longer a taboo word, at least among certain segments of the population. And these things may not create structural change through the legal system, but they might end up creating structural change over time, changing public opinion.
Yeah, no, thank you so much for this overview, but you still litigate cases of Palestinian rights in Israeli courts. And can you please share with us what is the possibility for accountability in Israel and why it is important to do that, and what are the expectations of your clients, and whether maybe Chantal can add whether that is relevant as well for future work of the ICC.
Yeah, right. This is a constant question, and it's one that I think it's very important that I and my colleagues continue to ask ourselves and ask our clients, because there is always kind of the elephant in the room, or the kind of what's hanging over us is the question of whether we should just boycott this system altogether. Whether going to the Israeli legal system gives it undeserved legitimacy. And I've come over the years to believe that the system, I don't want to be part of granting legitimacy to the system, but I do want to be part of using it strategically, using the system in order to accomplish a few different things. So, and this all is, when we say strategic, it means that first and foremost, we're selecting the right cases in which to do this. And typically this also means that everything, all of the reality of the system has to be understood by clients and attorneys together, right? So expectations are understood, and the reasons for going forward and litigating within the system is clear to everyone. And so the first reason to do it, I believe, is to gain information. A lot of times there are facts that are simply not available to us. They're in the hands of the army or the state authorities, and we do not have access to them as private individuals unless we bring litigation, unless a court proceeding forces that information to have to be shared in a response, whether that's in the military courts or in the Israeli High Court of Justice in an administrative proceeding. So not a criminal proceeding per se. In either case, there is information that's uncovered. It also, I think, can in many ways be a means of forcing the state or the military to articulate a policy and thus to reveal both to Israeli society, to Palestinian society, and to the world what its actual policy is. So in some cases, it means that we have access to army internal regulations that we wouldn't have had otherwise, or it means that the state has to come up with a clear policy. The big caveat to that is that sometimes that can do more harm than good. And we have to know that sometimes asking a state or an agency that has been inconsistent in how it applies, for instance, the punitive home demolitions policy, where sometimes a home is demolished, sometimes it isn't, or sometimes a judge will overturn a decision to demolish a house in front of a different judge or a set of judges. The outcome would be different. Asking the court to clarify, or asking the state to clarify its position on some of these policies can be dangerous. It can mean that we get a policy that means that we are consistently harming rights, as opposed to having some cases that turn out better. That said, it's also a tool for putting pressure on the state. It can be a rallying focal point for advocacy efforts, and most importantly, and I think this will be how I'll hand it over to Chantal. It is a source of verifying whether or not Israel is willing and or able to investigate its own crimes. And the reason why that's important, which I'm sure Chantal will expand upon, is because the ICC and actually other domestic courts, when functioning as universal jurisdiction forums, do not have the jurisdiction to take cases where a thorough and effective investigation and potentially prosecution has been carried out in the state where the defendants are. And this is something that needs to be tested in order to allege. And I think that this is going to be a very important point going forward in what the ICC will take up in terms of future cases.
Thank you. Just before passing the floor to Chantal, adding to what Emily was saying, so these decisions that are taken by Israeli courts, what is their relevance potentially for a case before the ICC for example, on discrimination. Is discrimination, apartheid, anyhow relevant within the jurisdiction of the court? And Chantal, can you tell us how far back the jurisdiction of the court would go? Like, could we have cases dating back to Operation Casled, or what is the time frame for the court, what we call temporal jurisdiction?
Yeah, there is a lot on the table already, and but starting from this last question, Grazia, the ICC will be able to go back to June 2014 with regard to the alleged crimes committed on the Palestinian territory, because, as I said, the court is based on a treaty, and the treaty needs to be ratified by the state. And from that moment, the court has jurisdiction. In the case of Palestine, it was January 2015. The treaty entered into force with regard to Palestine 6 months later, but there is a mechanism within the Rome Statute that gives the states the possibility to accept the jurisdiction of the court retroactively, so for the past. And this has been done by the Palestinian state, limiting, though, this retroactivity to June 2014, which means that the other very destructive operation against the Gaza Strip that I guess you will remember of that summer 2014, the so-called Protective Edge operation, will be included, and everything that happened after. But we cannot go back indefinitely. Actually, we cannot go back after June 2014. So this is already a limitation, but of course, many crimes, as the ones we are talking about, are continuous crimes. And one good example of that is apartheid. And I really want to go back to what Emily was saying about apartheid and what's happening in Israel recently about this shift of narrative, which was, I think, one of the most relevant things that happened in the past 2 years. Some very bold Israeli human rights organizations, those mentioned by Emily, started to consistently use this term, which we know how symbolic it is and how difficult it is to, I guess, to hear even from the Israeli society when the allegation comes from inside. So Israeli organization, champions of human rights, respected, well respected in the entire world. So it's not only now the Palestinian, which has since long have been saying what we are experiencing is apartheid, it's also the Israeli. And what it's crucial to notice that apartheid is a crime against humanity under the Rome Statute. So it is a crime under the jurisdiction of the International Criminal Court. And when we think of the interplay between what the national authorities, in particular now talking about the Israeli courts, are doing in terms of investigations or possible prosecutions of alleged crimes with the ICC, yes, of course, this will be one of the big obstacles, because Israel has a functioning judicial system, functioning in the sense that it is properly set up. Of course, we know the level of jurisprudence that also comes out from the Israeli Supreme Court is very high. I mean, they make really very, very high case law for certain kind of issues. When it comes to the Palestinians, the the things are different, and we have seen over the years a system, a judicial system, a legal system, I would say intentionally created to whitewash, to conceive, to guarantee impunity to those who have committed not only violations of human rights, but crimes against Palestinian people. So when the court will have to decide whether to take up some cases or not, they will have, so the office of the prosecutor in the first place, but then also the judges, they will have to adjudicate, they will have to assess whether Israel has already properly investigated and possibly prosecuted these allegations of crimes. And here it can be, I hope not, but I see it as a real risk that with regard to some allegations, in particular, war crimes committed against civilian population in Gaza, Israel will be able to show that a system of investigation, although it never brought to any conviction, was in place, and therefore Israel was willing and able, according to the language of the Rome Statute, to deal with these cases, and therefore the court should refrain from taking it. But absolutely nothing can be said with regard to other crimes like apartheid, exactly. And not only apartheid, of course, everything that goes around the settlements. So here I see a big crucial possibility that at least some investigations will generate cases that will hopefully, we hope, I speak also as representative of victims in the Palestinian situation before the ICC. So we really hope that these cases will be prosecuted before the International Criminal Court.
Thank you, Chantal. Thank you so much. No, it's interesting to hear that, you know, the apartheid case is certainly not being covered by current litigation in Israel or attempted litigation in Israel. In any case, I suppose that there's also an element of the proportionality between the alleged crimes and the convictions that we've seen in some Israeli cases in relation to protective edge, for example. So would there be a sufficient argument, like regardless of the proportionate punishment, would that be considered as in the test of willingness to prosecute?
I'll take this one. I think it's important not only to note the very small percentage of convictions that come out of Israeli military investigations, but also the type and identity of those who are convicted, which is primarily the lowest ranking soldiers. In other words, it's not a system that is equipped to effectively, professionally, impartially, promptly, right? We can go through all of the standards of a proper investigation according to international law. It is not equipped to investigate commanders, leaders, right? Who are much more of the sort of persons of interest when it comes to the National Criminal Court. There is a question about whether or not Israel's system could be considered legitimate. I myself have worked for years on analyzing and assessing that system. I represented in my career over 500 Palestinian victims of crimes committed by soldiers and border police. So I know the system intimately, and I would be the first to say that it is incapable and unwilling, both as a structural and as a kind of morale issue. And there's a lot to be said about that. But I also never did the same investigation of the British military investigation system, the American system, the Australian system, the German system. And I think it would be hard, given how much work Israel has done to align itself with specifically, I didn't randomly name those countries, with specifically those systems, with Canada and the Netherlands being added into there, that it would be very, very hard to claim that Israel's military investigation system is inadequate without also therefore then saying that all of those systems are inadequate as well. And that it would be difficult given the state of other legal systems that have come before the ICC, such as that of Bangladesh or Myanmar, etc. So I think that's a hurdle, and it's a shame because I think we have extensive evidence about the lack of true process within the Israeli system. That said, that's relevant to a certain bundle of crimes. The reason I went into some detail about settlements and home demolitions before is because there's absolutely no question about whether Israel is even attempting to investigate those who are responsible for those actions because they aren't considered crimes under Israeli law.
I would like to build on what Emily said about the conviction of low-level, low-ranking soldiers in general. Chantal, you're an expert of command responsibility. So would you like to comment on that and give us also a bit of an overview of what the court would do, given the competence of the court is for the most serious crime and the most responsible people? So do we really have an argument there that there is no chance that we bring the same cases to the ICC because they've been prosecuted in Israel?
I mean, in theory, under the Rome Statute, this is exactly what the prosecutor is supposed to do, focus on the responsibility of those that are higher up in the chain of command, both, of course, military and political, and not only those who are actively involved in the physical commission of the crimes or in the planification of the crimes, but also according to the Rome Statute, commanders and senior civilian leaders can also be, so politicians, for instance, can be also responsible for their failure. So according to an omission to prevent or to punish the commission of the crimes. So even if they were not actively involved. In criminal terms, we distinguish between commission, do something, and omission, fail to do something. So also omission can be criminally relevant, and it can be an international criminal responsibility under the Rome Statute. So yes, I do absolutely believe that a functioning ICC should and hopefully will focus on the highest responsibilities of the Israeli military and political apparatus. In that sense, for me, also the legal, the lawyers that are within the ministers, the military attorney general, their role is really crucial in what have happened for the past decades in Palestine, which, as I said, are continuous crimes, the settlements, apartheid, persecution. They didn't start in 2014. They will not end tomorrow. At the same time, I'm very worried because last December, the International Criminal Court, also the prosecutor, issued its decision in the situation UK-Iraq, which had to do with alleged responsibilities of British soldiers in Iraq in 2003 to 2008 during the military occupation of Iraq. And the allegations were very grave: torture, killings, inhuman treatment, very, very grave, and thousands of allegations. And the prosecutor found that these allegations were confirmed. These crimes happened. So no doubt about that. And the evidence is there. At the same time, they found that the UK had a functioning judicial system. And what for me, it's, I would say, even shocking, is to read after hundreds and hundreds of findings of confirmation that these crimes happened, and that in the UK, not one single case resulted in criminal prosecution. Nevertheless, the UK would have done enough. And so it's not possible to take up the investigations at the International Criminal Court. So I am worried, because this decision can have effects on other situations. And I am sure, as Emily said, that the Israeli, which since very long are copying, in particular, the British judicial system of, non-judicial system actually, of investigation, of military courts and so on, are taking very good note of what they need to do to escape a criminal investigation at the International Criminal Court.
Well, on these not so light notes, I'm asking a lot of questions, but our audience is free to ask questions via our chat. Please join me in doing that. Given that you're highlighting all these challenges when it comes to international jurisdiction, International Criminal Court, what are the other legal avenues available to Palestinian cases at domestic level outside Palestine and Israel? Can you, perhaps Emily first, and surely Chantal as well has some comments on that. Emily, what would you advise then?
Sure. I think it's important to remember that the International Criminal Court is not the only court in the world that has jurisdiction over war crimes. And that is both because there are many countries around the world that have at different times, and it's a little bit in flux, but that have accepted universal jurisdiction over alleged war crimes, alleged war criminals from outside of their territorial jurisdiction. So the concept being that there are certain crimes that are so grave that we as an international community, even when they don't take place on a particular country's soil and aren't committed by a particular country's own nationals, they cannot be allowed to stand without recourse and without justice being served. And therefore, we've seen over the years, particularly in Europe, different countries, and again, I say at different times because some have kind of gone forward, like Spain, for instance, with a few different cases like this, and then a little bit reined it back in for different reasons. But we have these doctrines in many different countries. Additionally, there is a very interesting and kind of growing trend or field to investigate and call for the prosecution of corporations or corporate executives, what's called sort of the corporate crimes, for their extraterritorial illegal activities. And in this case, the concept of universal jurisdiction in most cases doesn't even need to be triggered, because there are there are companies that are within that are nationals of a particular country that then participate in either directly or by aiding and abetting, by assisting the commission of crimes abroad. And so, for instance, right now we have, you can see ongoing trials against French corporation Lafarge for its alleged aiding and abetting of crimes against humanity in Syria. This is a construction or concrete corporation. There's an ongoing case in Sweden against Lundin Oil for its alleged activities or aiding and abetting of crimes against humanity in Sudan. And we're starting to see these kinds of investigations and indictments pop up in different places around the world. So what this means is two things. One, that we're able to focus on these crimes from an additional angle, which is not only the state actors, but also the corporations that are, in many cases, actually enabling and facilitating, and without which these crimes wouldn't be able to go forward. If you think, for instance, about the settlements, every construction of settlements of infrastructure, right, is contracted out by state authorities to private corporations. Some of them are Israeli corporations, some of them are foreign corporations, and they would come under the jurisdiction of their own country's laws. And so, to the extent that those countries do have full and robust legal systems and criminal codes that address war crimes, they are subject to them. But it also means that there is an avenue for exploring some of the crimes and some of the actors that wouldn't reach the threshold that the ICC requires. So the International Criminal Court typically extends its jurisdiction over some of the more grave crimes and the more direct perpetrators of those crimes. In fact, it does not have jurisdiction over corporations at this point. But this means that there is an avenue for maintaining accountability over some of the crimes and some of the actors that wouldn't otherwise meet that bar. And I'm sure that Chantal has more to say about that than I do. But that, I think, is a promising avenue that we should be paying attention to.
I actually do have a question for Chantal. How is the Italian legal system equipped to act, as Emily was describing, exercising responsibility, legal action towards against Italian companies possibly involved in activities in the occupied territory, illegal activities, clearly?
No, not very well. Not very well, because we do have responsibility of cooperation. It's a technically administrative responsibility for the commission of crimes, but it's a quasi penal criminal responsibility. The problem of the Italian legislation is the lack of, we don't have international crimes. We don't have war crimes in the sense of the jurisdiction of the ICC. So we don't have crimes against humanity. We don't have, we didn't implement the Rome Statute. So we do have all the military codes that, of course, have war crimes in the sense of if an Italian soldier goes abroad and breaks the law, then he can be responsible for, but it's a completely different concept. So actually, Italy is not a venue that was, it is sometimes considered if there is an Italian company that is aiding Israeli companies in doing work in unlawful, let's say, settlements. Breaching human rights obligations. There were some attempts, but so far with no success. But what I would like to say here is that the Palestinian lawyers and Palestinian human rights organizations that represent since decades, of course, the Palestinian victims, have strategically thought about legal venues since many years. I personally started to participate in these strategic discussions back in 2009. And since then, we got to meet many times. There is like, you have to imagine that there is a core of, let's say, lawyers around the Palestinian organizations, and the Palestinian lawyers constantly thinking, strategically thinking about legal venues. And many legal venues have been tried in the past, including the UK, France, the US, other European countries, and Germany. And in particular, there is a case that we currently have open in Germany that is about the killing of the Kilani family during Protective Edge in 2014. So an entire family with 5 small children was killed without, in our view, without justification. And the interesting detail of a story, which is terrible as many others of that summer, is that the father had the double nationality, so was also German. So were their children. And we brought this case in Germany, which should actually be quite automatically opened, at least in the investigation stage, as the victim was German, also Palestinian, but also German. And we see that more than 6 years later, there is still no investigation on this case. There is, again, what is called a preliminary examination. And until now, the German prosecutor took the stance that they are waiting to see what happens in Israel. But we provided many information over the years to show that in Israel, this investigation is absolutely closed. There was nothing. And still we are fighting and not having any result. So this just to say how difficult, how high is the threshold when you bring a Palestinian case. There is a political component that comes into play. I have seen there is one question, if I can, in the chat. Yes, can I pick it? Because it's...
Sure, as you like, I was going to, yeah, if it's pertinent, yeah, sure.
Because there is this question, I don't know anymore who put it, Leila, I think, about something that happened today, that is that the German Minister of Foreign Affairs affirmed that Germany is against the ICC decision that the International Criminal Court has jurisdiction over the Palestinian territory because Palestine is not a state, and this is German position. And this is, again, this shows the politicization of an issue, which, of course, as the pretrial chamber correctly said, has political aspects, but it is also legal. And by the way, every crime under the jurisdiction of the court, war crimes, crimes against humanity, aggression, genocide, has a political component in the sense that involves the state apparatus, almost by default. These crimes are so widespread and big and systematic that are normally the outcome, the result of political decisions. this doesn't exclude that there is a legal dimension of these crimes. And this is exactly what the ICC will be dealing with and what we as lawyers need to deal with. I don't want to deal with the political dimension of this situation. There is a political situation, we cannot ignore it, but the bottom line is that serious crimes have been committed against human beings, and we agreed, not now and not for the Palestinians, but more than 60 years ago, that these crimes should not go unpunished, and individual criminal responsibilities must be assessed, must be adjudicated, because there is a need to break the circle of impunity which fosters violence. So for me, this is the most important point to stress. Without denying the political aspect of this situation, there is a very important legal aspect. And this is why the German position, especially because it comes from Germany, which is otherwise a huge champion of human rights and is doing a lot on other levels to enhance human rights, and also internally exercising universal jurisdiction, for instance, for the Syrians, is denying the possibility that Palestinian victims access justice in an international forum. This, for me, is unacceptable.
Thank you, Chantal. Thank you as well for going into the questions from our audience. And again, on a similar issue, there is another question related to the recognition of the state of Palestine and whether that recognition has any relevance with regard to the responsibility for crimes against humanity. And if this is of any relevance for the ICC, as a matter of fact. But as you explained earlier, the issue of recognition of states is not necessarily a matter that the ICC will look into. Can you please clarify the point?
No, because they don't need to. They don't need to do it. Palestine had a status at the international level good enough to ratify an international treaty. By the way, the Rome Statute is not the only international treaty that Palestine ratified. They ratified the Geneva Conventions. They ratified UN treaties against torture, against a number of violations of human rights. It means that the Palestinian government took the obligation to respect these treaties with all the consequences that it implies, including the International Criminal Court. So when they did so in 2015, this ratification was considered valid. It passed through the UN system. It passed through the independent system that manages the court, which is called the Assembly of the State Parties. And there was no objection to Palestine becoming a state party. So I don't really see, legally speaking, the point now for some states that intervened in the proceedings, as Germany did, but not only Germany, 5 states, Australia, Hungary, Austria, and I'm sure I'm forgetting Brazil, to say, we don't think Palestine is a state and therefore the ICC cannot have jurisdiction. First, they should have said it before. Second, the court is not deciding once and for all which is the status of Palestine under international law. Again, this is a matter of bilateral mutual recognition among states. Is one of the most complex issues in international law. The court is aware of that. Is not trying to supersede diplomacy or states' bilateral relationship. What it's saying is, for our jurisdiction in front of the court, Palestine can be considered as a state. And it's not a strange invention, by the way, because there is a concept in legal proceedings that is the functional interpretation of treaties. This is not, again, an invention of Palestinian advocates. It's something that exists under international law. So the court can decide just for what it matters, which is its jurisdiction. And clearly, in 2015, when Palestine was admitted as a state party, it would be an absurd result now to say, oh, sorry, for 6 years we considered you a state, but actually, no, we cannot consider you a state, so there is no investigation.
Yeah, no, I know I mean, I'm asking also questions that are coming from the public just to clarify this issue of the recognition of states and how it's not relevant for the purpose of the ICC, given the situation and given the determination of the 5th of February. A very interesting question has come on more Israeli-related matters. So I would pass it on to Emily. There's a question regarding the relevance of evidence or say information collected by human rights organizations in Israel or Israeli organizations as such, given the recent technological tools that we have. Would they be relevant or to be used before the ICC, Emily?
They would certainly, they've certainly already been used within the preliminary examination. There were several organizations and of course the Palestinian leadership itself and through the large team working on this has submitted lots of forms of documentation. I think that there's always going to be a question of admissibility, and some of these apps and tools, et cetera, are becoming very, very good at preserving, for instance, chain of custody, so that evidence to the court can be sure that, or the investigators can be sure that evidence hasn't been tampered with at any point along the way. But it really will depend on this kind of technical question. Yeah, I don't know if Chantal, you want to add on that?
Chantal, would you want to comment on that? I think Emily has fully explained what the situation is. And I have here a question, which I'm going to read verbatim. So even if the ICC issues arrest warrants against specific Israeli officials, Israel will never hand over these officials to the court. In turn, the US will veto any Security Council resolution through which Israel could be compelled to cooperate with the ICC, International Criminal Court. This would basically neutralize the International Criminal Court as a way to achieve accountability. What do you think about that? Chantal and Emily in turn, because I'm sure you both have something to say on this.
I mean, I'll just quickly say that this wouldn't be the first time that there's been a trial at the ICC in absentia. It's something that the court is capable of dealing with. I think the question of legitimacy of the court is an interesting one, and I think, you know, over the past several years, and of course particularly under the kind of Trump and Netanyahu relationship, there was a very strong condemnation of the court. But I don't think that this particular aspect would completely delegitimize the court going forward. I think what will determine the court's legitimacy is how other countries end up responding. So I think it's very relevant what Chantal said about Germany. I think Germany specifically is quite sensitive to the idea of trying Israelis for war crimes, given its own history. I think, you know, we really need to look to and maybe even call on other, particularly European and EU countries to make statements that support the functionality of the court.
Chantal, do you have any comment
Yeah.
on that?
Yeah, I mean, the issue of the warrants of arrest, yeah, the court can conduct investigations and in exceptional cases can even arrive to the confirmation of the charges without the person being physically there, but cannot proceed with the trial. So it will be necessary indeed to, if they have an accused person, that this person stands trial in presence. But we are still very far from that, from there. And I think it's important that we already ask ourselves what will happen when, if, but maybe it's not now yet the right time. We will see. Also remember, people travel. It's not only about like, yeah, maybe someone will be targeted by a warrant and maybe doesn't know and travels, gets arrested somewhere else. In Europe, we have a very strong system of cooperation for in that regard. I don't know. I don't think we need to speculate too much at this point about what will happen. We are very far, as I said, from that. And about the UN Security Council, I don't really see the point because the court is independent. The court doesn't need any Security Council resolution. There are 123 states that are already state parties. They could cooperate with the court. Yeah, the UN Security Council could come into play to extend to other states that are not state parties to the ICC. Yeah, for instance, the request to arrest someone. And maybe you're right, probably we will never see such a resolution, but also we don't need it now. What we need is to go step by step. Remember what is the purpose of the court, which is to conduct criminal investigations against individuals and possibly have criminal prosecutions when cases will be considered to be strong enough to go to trial.
No, I agree with you that the step-by-step approach is the best one to go for and not jump in the guns. There's another question that I think is for you, Chantal, given that the question is about whether or not Italy exporting weapons to Israel, weapons with which violations of human rights are being committed, is Israel in violation of its own norms, of its own laws, and what kind of responsibility this kind of trade entails?
Well, when you say criminal responsibilities for Italy, I don't know, but responsibilities for Italy at a level of state authorities who authorize these exports, yes, I believe there are responsibilities, because Italy has one of the strictest laws with regard to the export of weapons. So actually, because of the consistent documentation about commission of serious violations of human rights and possibly war crimes by the Israeli military forces, this should be enough under the Italian law to not authorize the exports of arms to Israel. I'm very happy about the decision of the Italian government of 2 weeks ago regarding Saudi Arabia. And so, of course, Yemen is the conflict where these weapons were used, and it's historical. the Italian government was very, very good because the decision is also retroactive. So it really, it has a huge impact. We will see if it will be appealed. I hope there will be more decisions in this sense. Yes.
Thank you, Chantal. There's another question that I think is quite interesting. Perhaps Emily has some ideas, given that it might take the Israeli society and public opinion. There's this perception that the office of the prosecutor, it's not just a perception, it's reality, could be under a lot of pressure, and there are risks as a result of them undertaking an investigation on Israeli perpetrators. What could be a shield, something to protect the office of the prosecutor and its staff from being attacked or from being subject to restrictions or sanctions, which is already the case, as we know, in the US. So what do you think, Emily, could be a strategy to prevent that or to mitigate that?
That's a very interesting question. I don't have an idea off the top of my head right now. Maybe I'll think a little bit out loud. I mean, what I want to say is that in some ways Israel speaks in two voices at the same time. And what I mean by that is that on the one hand, there's a lot of, rejection of external adjudication, judgment of Israel's actions. The term apartheid is so insulting, as Chantal said before, to Israelis because they are, for the most part, convinced that their policies towards Palestinians have nothing to do with racism, which is what they see apartheid being about, and rather about security needs and security interests, and therefore that it is a legitimate set of discriminatory laws and rules and policies. So it is incredibly insulting to Israelis, and the leadership kind of puffs itself up and acts as though it is not threatened. And yet we also have, I think at some point last year, it was leaked that the Israeli Ministry of Justice was had long been compiling a list of what it viewed as potential suspects for a future ICC investigation that now had more than 100 names on it. The leak, included some of the usual suspects, but didn't give us the full list. We also see how, again, Israel rejects the United Nations as being disproportionately critical of Israel, as being the General Assembly being a political body, certainly human rights. The Commissioner on Human Rights, and of course the UN database that came out or that published the list of corporations involved in the settlements and more. And yet Israel shows up every single time for its periodic reviews, for reports to all the committees that it's part of, and spends a tremendous amount of time and effort to try and make a legitimate claim that it is upholding these treaties that it is a part of. So what I'm saying is that there's at the same time an effort to pretend that Israel isn't influenced by the international legal system, and on the other hand, a lot of effort to at least cosmetically make sure that it is abiding enough to get by. I think in addition, Israel is hoping and leaning on, and we see that again from the headlines, and even as I'm sitting here, from a push notification that I got, that it was relying on an administration to kind of go to battle for it. So we'll see.
And Chantal, on the same question, do you think what is the civil society organizations can do to create potentially some sort of protective shield for the office of the prosecutor to be not to be under these types of restrictions, pressure, political blackmailing? Do you have any ideas?
Yeah, I think first of all, the mechanism needs to be exposed. So we need to keep talking about it for what it is. Why was the Trump's executive order issued to shield possible perpetrators of grave crimes in Afghanistan, US perpetrators, and now the link was done not only now, actually already at that time, also for possibly shielding Israeli, their allies by prosecutions or even only investigations at the ICC. So yes, the civil society plays a very important role, and it is already playing this role by issuing statements and by also signaling its support to the office of the prosecutor. But in the end, I think it's the states so that will need to be pressured in order to change this. So what I would like to see is advocacy groups lobbying their governments that support the ICC to make sure that these kind of threats are retreated, and in particular the US executive order sanctioning the prosecutor, which is again incredible to see, because normally that kind of executive order targets suspect terrorists or very serious criminals, not the prosecutor of the most important criminal court in the world, gets repealed. So we need to keep this pressure on our representatives as well.
Thank you so much, ladies. Really, I'm afraid we're running out of time. I'm really sad about that because I'm finding this discussion really interesting, and it's been really inspiring to hear all your knowledge and enthusiasm, and the realism of the difficulties as well. And it's also important that we've had some ideas as well for civil society organizations. So I thank you again. I thank the organizers of this event, Civil Society for Palestine, Arci, Coste, and FIOM CGL Lombardia. A big thank goes to the interpreters who've done a tireless job in trying to convey all these very technical concepts to our audience this evening, both in Italian and Arabic. Thank you very much, guys. And I invite you to follow us on our Facebook page, and to our next event, which will be on the 3rd of March. We'll be talking precisely about global campaigns and human rights in Palestine. So exactly building on what Chantal just mentioned, of what civil society can do in putting pressure. And our last event will be on the 25th of March, same time, 6 p.m. And it will be about networks. So let's team up international civil society movements and initiatives to support Palestinians' rights. So thank you again, Chantal. Thank you again, Emily. And good evening to you all. See you in a couple of weeks.
Thank you, Grazia. Thank you all.
Thank you.
Bye-bye.
Good evening.
Good evening.
Bye now.
Bye.
Ciao.
Ciao.
Ciao, esatto.